Voice Radio, covering the latest state and local issues with Tom Fallbush, Bob Scott, and Jim Waters.
Hello, Kentucky, and welcome to this Friday and to a great start to this Labor Day weekend. I'm Greg Williams, President and CEO of Building Healthy Relationships, known as Love and Lordship, and you're listening to Kentucky's Voice on 970 WGTK, or possibly viewing on WBNA Channel 21, where faith, family, and freedom are the priorities. I'm excited to host today's program as we discuss the cultural, legal, and spiritual issues that affect our Commonwealth and nation, and how we as people of faith and conviction can respond with integrity and courage in truth and love. Now, you're definitely going to want to stay tuned for today's program, as I'm excited to welcome two excellent guests, one from right here in Kentucky and the other from sunny Florida. Today's topic, or topics, will focus on the real threats and actual consequences of Obergefell. If you're not clear on that, stay tuned. The foundational institution and value of marriage and why it must be restored. Before we welcome our guests, our first guest, I would be remiss if I didn't mention and ask for prayers for those in Minnesota with the shooting, for the school children and their families, and even the family of the shooter as well. It's so sad, and ask that you continue to pray for all involved. Building Healthy Relationships, or Love and Lordship's vision and mission, is to restore and help maintain a biblical worldview through healthy people, relationships, families, and communities that are foundational to thriving societies, governments, education, and all cultural influencers and outcomes. On the first half of today's program, we welcome Mr. Matt Staver, founder and chairman of Liberty Counsel. And in the second half, we welcome Mr. Martin Cothran, senior policy advisor for the Family Foundation here in Kentucky. Matt, first of all, thanks for taking the time to join us. And I know you're extremely busy on several fronts and have won some great victories. Praise the Lord for that. Thanks for joining us.
Thank you, Greg. Good to be with you, of course.
Yeah. Let's start with this, Matt. Give our audience a brief intro to the Liberty Counsel. I mentioned it in the intro.
Well, Liberty Counsel is a religious liberty organization. We advance religious freedom, the sanctity of human life, and God's design for marriage and family through litigation, education, and public policy. We've been in existence since 1989, when my wife and I, Anita Staver, who's also president and general counsel of Liberty Counsel, founded Liberty Counsel. We have offices in Florida, Virginia, and Washington, D.C. We have affiliate attorneys in every state, and we are working across the nation. All of the work that we do at no cost and pro bono. We have a lot of critically important cases that we have done in Kentucky. And my wife actually was born in Winchester, Kentucky, Clark County, Kentucky. So we have a lot of affinity to the Commonwealth of Kentucky.
Well, I love you guys. I won't hold that against her, since I was born in Harrison County, Kentucky, and we're rivals. But I'm actually doing a little revival that we've been promoting a little bit in a couple of weekends in Clark County. So that's great. By the way, join us. Text your questions or comments to 502-571-0970. If you believe in the mission and would like to financially support us, text KY Voice to 53555. Matt, you mentioned that you guys have in almost every state, if not every state, and I know you've had numerous highly visible and extremely important cases on constitutional rights and freedoms over the years, but few may be as important as the one you're in the middle of right now. Tell us what's going on with Kim Davis, the former Kentucky clerk, right here in Moorhead, Kentucky.
Yeah, 10 years ago, she spent Labor Day in prison in Kentucky because she was a prisoner of her faith. She was a Round County clerk elected by the people to serve. And then on June 26, 2015, the Supreme Court, with an opinion, Obergefell v. Hodges, issued a 5-4 opinion that purported to redefine the definition of marriage. And as a result of that decision came down on a Friday. She returned to work on Monday, and Kim would not violate her Lord and dishonor him by putting her name and title and authority on a license regarding marriage that God does not design or approve of. And so she simply asked for an accommodation to remove her name from the certificate. That's very simple. And when she didn't get that accommodation, the federal judge in Kentucky, Judge Bunning, sent her to prison for 6 days, and that was 10 years ago. Labor Day weekend when she got out the day after Labor Day. She would have stayed in there longer because the judge said, you're going to stay in prison until you agree to put your name on the marriage licenses. Well, she would have still been there because she's never going to do that. He eventually did let her go because there was so much international and local and national pushback that he let her go, actually right during the middle of a rally that was being conducted the day after Labor Day.
Yeah. So that's literally 10 years ago this weekend. I mean, we're
right
in that right now again, as you said, and we remember it well here in Kentucky, and you have some Kentucky roots as well. So it was fascinating to see what happened.
Well, 10 years ago this weekend, I flew to Kentucky and I went to the prison. And I'll never forget that moment when I saw Kim Davis. She was dressed in an orange prisoner's jumpsuit. They put us in a secure area, and I was there. I hugged her, seeing my client, a humble, godly woman whose life had been radically changed by the Lord a few years earlier. I was speechless. I could not speak. And the first words out of Kim Davis's mouth was, "All is well, all is well." And I'll never forget that. She's an amazing individual. As a result of her going there, the men who were in the violent 10-year-plus incarceration section of the prison, they sent her cards saying that they were praying for her.
Wow.
The women who booked her were Christians, and they wept as they were booking her into the prison. But it was a very spiritual moment for her as she sat in prison, studied the Bible, sang Christian songs that other people could hear, and read from the Bible where the Apostle Paul wrote some of the letters that we have in the New Testament from prison.
Yeah.
And now here she is, a prisoner of her faith. So she asked for an accommodation. She doesn't get it. She gets thrown into prison for 3 days. While she's there, one of the deputy clerks actually removes her name from the certificate, issues it to 3 different same-sex couples. The one set of couples that had sued her, they went away. That's all they wanted. The other 2 sets of couples said, no, we want Kim Davis's name on our license. They wanted Kim's name on their license. Yeah. They could have gone any place. They actually had their certificate. They could have gotten it from any other place, but they wanted Kim's name to mock her Christian faith. Yeah. And so they went back to the court asking the judge to hold her in contempt. The governor then, Stephen Beshear at that time, said originally no accommodation, but then when he was asked, what about the certificate without her name that was scratched out? He said, oh, that works. So he actually allowed the accommodation, but she'd already spent time in prison. So then a new governor gets elected, Matt Bevins, a Republican. He issues an executive order in December of 2015, granting exemptions for all clerks. And then the legislature came together unanimously. They passed a law in April of 2016 granting accommodation for all clerks. So the question is, she got the accommodation in multiple forms and fashions. They got their license. Why does the case continue? It's because 2 of those sets of plaintiffs were vindictive and they wanted to personally punish Kim Davis. So they continued to press their case. They amended their complaint, came after her personally as an individual, not only as a representative of Kentucky, but as an individual. They said that they had hurt feelings. They wanted emotional distress damages. We went to a jury trial in 2023, 2 juries in the same courtroom at the same time hearing the same evidence. One jury came back after 45 minutes, 0 damages for the one set of plaintiffs. That case is gone. And the other jury inexplicably comes back and gives $100,000 collectively for damages for David Ermold and David Moore.
Yeah.
And there's no lost wages, no out-of-pocket, no treatment, just hurt feelings. And so now that case is the case before the United States Supreme Court. So we have 2 questions. One, that Kim Davis should have an absolute defense under the First Amendment free exercise clause. And number 2, and most importantly, the Obergefell opinion from 2015 should be overturned.
Yeah, that's excellent. Thanks for clarifying. Maybe a lot of our listeners didn't know all that story. We've got less than a couple of minutes here, Matt. So I want to lay this out. We may come back to it in the next segment. I believe it's foundational to the initial case. Please help our audience understand the differences, if any, or not, between an individual's freedoms and that same person having the same freedoms when acting in their government responsibility.
Well, originally they sued her as a representative of Rowan County, Kentucky, and the Commonwealth of Kentucky. And of course, in that particular situation, all they could get was an injunction, but no damages. You can't get damages against the state. Well, they got the license that they wanted, so the injunction was moot. So that basically wiped out the case. So then they wanted to come after her personally. So they argued that she should have no governmental protection, and they're suing her personally. So this damage award, the $100,000 plus $260,000 in attorney's fees, $360,000 plus in counting, that's against Kim individually, personally, not against the government, not against Kentucky, not against the county, against Kim personally. For what? For hurt feelings. Yeah. This is an outrageous case, and it ought to catch the attention of the U.S. Supreme Court.
Yeah, and we're all praying that it does, and praying that they have the sensibility in this case, much like overturning Roe, that they see not only this case, but the damage that's been done since Obergefell. And so we're gonna come back here. Join us again in Texas, 502-571-0970.
Are you ready to stand for truth?
Great, Matt. Thank you.
Kentucky is at a crossroads, and we need voices that won't back down. This is your moment to rise, speak up, and be part of a movement that's changing the narrative in the Commonwealth. Kentucky's Voice is calling on bold citizen journalists, fearless editors, and those unafraid to speak truth in the public square. Volunteer, intern, contribute. Scan the QR code or visit kyvoice.org to join the fight. This is more than media. This is your moment. You are Kentucky's voice.
Voice Radio, online at kyvoice.org.
All right, I want you to check out this clip before we get into segment 2.
The U.S. Supreme Court could be facing a decision on same-sex marriage. It all stems from one woman's case. And you may recall back in 2015, Kim Davis was a county clerk in Kentucky who was jailed for refusing to issue marriage licenses to gay couples on religious grounds. She's appealing that ruling to the U.S. Supreme Court and in turn also asking the justices to overturn a 2015 ruling that legalized same-sex marriage. Now, we spoke with a legal expert for some insight about this case on Seattle News Tonight. She says there is a chance the Supreme Court will hear this case, but the question is, what parts will they hear?
The two parts are she has a main personal claim that says I should not have been sued for emotional damages under what's called a tort claim because I should have immunity as a state actor, or if I don't have immunity because I was acting as a state actor, I should have protections as an individual who gets to practice their First Amendment rights. That's really the bulk of what this claim is about. The part that's getting the most attention is the part that you have asked about, which is overturning Obergefell, which is the same-sex marriage case.
If the Supreme Court decides to take the case, it'll likely be scheduled for next spring.
So with that video clip as a backdrop, we welcome back Mr. Matt Staver, chairman of Liberty Counsel and the legal representative for Kim Davis in two petitions now being considered by the Supreme Court. That in and of itself is a victory, and we hope it continues. Many staunch liberals and liberal media clearly tried to make the case that the Supreme Court would not even consider these cases. As with almost everything dealing with this and related issues, there's a great divide along ideological and liberal conservative lines in the discussions as to how this now plays out in the highest court in the land, and we sure hope it gets there. Matt, welcome back.
Thank you. Good to be with you.
Yeah. Thank you for the clarity on Kim's and our First Amendment rights. We talked about that a little bit. I want to get into that, but I also want to come back to or introduce this. You're asking for the Supreme Court to rightly constitutionally overturn Obergefell. And I shared with many at the time that Justice Kennedy's majority opinion was the apex of many of his judicial decisions and writings. It was double-mindedness. Please share with us more prominent issue of the fallout and potential of overturning Obergefell, which is clearly a right created by the earlier court out of thin air. It's not in our Constitution. Speak to that, Matt.
Yeah, let me address a couple of things here. We need 4 justices to agree to take a case. We need 5 justices to win. So we have 3 justices that clearly have already made their opinion known on Obergefell, and that includes the Chief Justice John Roberts. He read his dissent from the bench. Now, justices only do that on a very rare occasion, and he's only done it once in his entire career, and it's on this case. So he read his entire dissent. His entire dissent is very powerful. Why did he read it? Because he was so opposed to the 5 lawyers, and he called them 5 lawyers in a derogatory fashion. He said 5 lawyers imposed their will, not a legal judgment, and their opinion has nothing to do with the Constitution. They wrote their own view of marriage contrary to millennia of human history, and he was very, very adamant about this. The Justices Thomas and Alito also dissented as well. And Alito said, I fear that what this case will do is make targets of individuals, and they will be discriminated and persecuted because of their faith. Well, Kim Davis was the first example of that. Right away in July, she became the target, and then she went to prison at the end of August, at the beginning of September, I should say, over the Labor Day weekend. And so all of those came to pass. Now, we also have the decision in Dobbs that overturned the abortion decisions in 2022. And that was based upon overturning this idea of so-called substantive due process, which is not in the Constitution. Substantive due process has nothing to do with the Constitution. There is a due process. It's procedural. You have a right to know what you're charged with and a right to defend against that charge. That's obvious. Substantive due process is a liberal invention of judges, and that's what was rejected in the Dobbs abortion decision. And so Justice Thomas said there are other cases that are built on this faulty foundation, and he named one specifically, Obergefell. And then later in another case, Justice Alito, in a jury selection case where someone was removed from a jury because of their views on homosexuality, said, I told you this is what's going to happen with Obergefell. So we have some strong opposition right now to Obergefell, but also in the Dobbs case, Gorsuch wrote, when the Constitution is silent, the court ought to remain neutral. The Constitution was silent on abortion, so the court ought to remain neutral. Well, the Constitution is silent on marriage in general, and certainly same-sex marriage in particular. The court ought to remain neutral. So I believe, there's strong views on the Supreme Court that I think could overturn Obergefell. We're asking for, obviously, Kim Davis to be protected under the Free Exercise Clause of the First Amendment. They could decide that and not overturn Obergefell, sure. But the problem is that's just a Band-Aid on the cancer. Yeah, that would be a great win, certainly a great win. But what caused the problem? Yeah. It's not the First Amendment. It's Obergefell. It has nothing to do with the Constitution. It's an aberration. And it's so much in opposition to the chief's viewpoint of how the court ought to act. That's why he read his dissent from the bench to emphasize it in bold letters, if you will, how much he was opposed to Obergefell.
Yeah. Excellent. Now, by the way, join us. Text your questions or comments to 502-571-0970. That's 502-571-0970. If you believe in the mission of Kentucky's Voice and like to financially support, text KY Voice to 53555. That's KY Voice to 53555. Matt, I said 10 years ago when Obergefell was decided, if we wait 50 years like we did with Roe, there'll be significantly more damage done on this one than even was done with Roe. And here we are 10 years down the road, which is 9+ years too many, but it's much quicker than 50. You just described, I think, why we're in this situation. What do you see, and how can we pray for clarity for the justices, for you, and against the schemes of those on the other side?
Well, the other side has until October 8th to file their response, and then we'll file a reply. The justices will then convene what's called a conference. That'll be toward the 3rd, 4th week of October or early November, and they'll decide whether to take the case. So pray that we have a minimum of 4 justices who say, yes, we need to take the case, and obviously a minimum of 5 justices for us to win this case in 2026. A decision would be handed down no later than the last week of June 2026 if the High Court takes this case. So pray for favor with the clerks of the justices and the justices themselves in this upcoming October-November vote. And then also for favor as we move forward with this case, but also pray for protection for Kim Davis. She has faced, and her husband Joe, death threats. The more this is in the media, the more threats we have as well. We've taken additional security precautions because of the crazy threats that we get. And certainly we get threats on this particular case and have gotten increased threats. But, I think we are in a situation where I've always said, even after Obergefell, right when it was decided, it's not a matter of if it will be overturned. It's just a matter of when. There's no question it will be overturned. Mark my word, Obergefell will not last long. Whether it's this case, which I believe this case has compelling facts and law to overturn it, I don't know. But it will be overturned. And I believe this case has the potential to do it. And this case is the reason why they made this mess, is the reason why we're here, and they need to fix it.
Yeah. And you've given plenty of information and facts about justices that made that point clear. So appreciate that. We need to be praying along those lines. And for you, clarity and discernment for you. You've done this many times, but I know you always welcome that.
Absolutely.
Yeah.
And
Matt, thanks. Go ahead.
If you want more information about the case, you can go directly to lc.org/Kim. lc.org/Kim will update whatever happens on this case.
Excellent. Matt, thanks again for taking the time to join us and help us understand these crucial issues, how to pray for extremely important cases in this pivotal moment in our nation, direction and continuance. Stay tuned for the second half of Kentucky's Voice as we welcome Mr. Martin Cothran and take a deep dive into the cultural historical issues with regard to Obergefell and the opportunity for it to truly be overturned.
Voice Radio, online at kyvoice.org.
Please listen to a key portion of the audio version of the article written by Martin to introduce this segment and our next guest.
Not vote to redefine the most foundational institutional of human society was Antonin Scalia. As was his practice before his death in 2016, he was able to beautifully capture the absurdity of liberal jurisprudence as applied, this time, to marriage. 5 justices who compose today's majority are entirely comfortable concluding that every state violated the Constitution for all of the 135 years between the 14th Amendment's ratification and Massachusetts' permitting of same-sex marriages in 2003. They have discovered in the 14th Amendment a fundamental right overlooked by every person alive at the time of ratification, and almost everyone else in the time since. They see what lesser legal minds like Thomas Cooley, John Marshall Harlan, Oliver Wendell Holmes Jr., Learned Hand, Louis Brandeis, William Howard Taft, Benjamin Cardozo, Hugo Black, Felix Frankfurter, Robert Jackson, and Henry Friendly, could not. To say that Obergefell was an assault on common sense and the democratic process is an understatement. And it wasn't only conservative minds that were...
Now, what you just heard, as I mentioned, is an audio clip of the article written by our next guest, Mr. Martin Cothran, Senior Policy Advisor for the Family Foundation. First appeared on the Family Foundation's website and then in Kentucky Today. And by the way, it will be in the Family Foundation's Kentucky Citizen in September. It gives compelling reasons from one of the greatest minds and constitutionalists in SCOTUS history, Supreme Court history, that is, as to why Obergefell was wrongly and egregiously decided when it comes to the Constitution and 14th Amendment, over a century of history and common sense based on that history. So with that as our intro, we welcome Mr. Martin Cothran into a deep dive on several levels as to why this case needs to be overturned. Martin, first of all, welcome and thanks for joining us on Kentucky's Voice.
Good to be here, Greg.
Great. Would you give our audience a synopsis of your article, and then we'll jump into the specific reasons for the need to overturn Obergefell?
Yeah, well, I think I was simply making the case, just to make this real simple, that the court was making law rather than interpreting it. I mean, at the heart of this issue is the fact that you had judges who are supposed to be referees making substantive decisions, that basically determining what the law should be, rather than what the law actually is. No one ever legislated. I mean, they tried to legislate same-sex marriage, but were unsuccessful. The laws that were struck down, the democratically made laws that were struck down, were the ones preventing same-sex marriage. And I think I can't remember if it was this article or another one. I called it the undemocratic view of law.
Yeah.
And so I think that's the main point here, is that you have rogue justices who are supposed to be judges and they're acting like legislators.
Yeah, and we're going to get into that a little further now, and why, because of that, it needs to be overturned. Join us. Text your questions or comments to 502-571-0970. That's 502-571-0970. If you believe in the mission and Kentucky's Voice would like to financially support, text KY Voice to 53555. Thank you, Martin, for first of all writing that article and then being willing to share with us here on Kentucky's Voice. You mentioned in the article that throughout recorded history, and that's 6,000 or so years, that up until 25 to 30 years prior, that the truth of marriage had never even been questioned. What changed at that time?
We had people who, we get into the whole issue of homosexuality and all that, but who wanted to honor homosexual relationships with a title that has always been reserved for male-female relationships. Yeah. And all of our laws are premised upon that. And so they came along and they wanted to have those relationships called marriages. The public said no. And so they decided to go and argue their case in the courts. Yeah. Virtually all the major liberal decisions that have been handed down in the United States are anti-democratic decisions. They're overturning laws, preventing certain things that were written by elected representatives.
Yeah. Explain what you mean by anti-democratic to our listeners and audience.
Well, what I mean by anti-democratic is the way our system is supposed to work is the legislative branch makes the laws. Right. The executive branch enforces them. And then the judicial branch interprets those laws. But what has happened is, in order to get their agenda furthered, they have turned the courts into a legislative branch in many cases. Now, right now, that's different now because we've had conservative justices put on the court, and they don't like that. That's the whole difference between liberal judges and conservative judges. It's not really substantive things, but process things. Yeah. That judges are supposed to be referees. They're not supposed to be putting their weight on one side or the other.
Lawmakers.
Lawmakers.
Right? Yeah, yeah. Well, in the intro clip of your article, I highlighted Justice Scalia's well-reasoned thoughts as to the lunacy, for lack of a better term, of this decision. You also include a quote from the New Republic article on the disaster of Kennedy's writing of the majority opinion. Could you elaborate on that a bit?
Well, it's been a while since I read that decision, but I remember when I was reading it and thinking, this makes no sense at all. And so I quoted the New Republic article because the New Republic is a liberal publication.
Right.
And the writer who wrote the article was a liberal himself. And even he had to admit how bad it was. It was just very poorly reasoned.
Yeah. I mentioned this with Matt, our guest in the first half hour, who's representing Kim Davis in what we hope gets before the Supreme Court. But I mentioned that on these issues, Justice Kennedy would often, it would seem like he was speaking out of both sides of his mouth, which is why you couldn't make clear. But I don't think it was ever more than in that majority opinion that he wrote. And I think that's why you even found a liberal article that said, this makes no sense. You know?
Well, yeah. And what he was doing is what this whole, and it's a technical term, but that substantive due process. Mm-hmm. Okay, the word substantive, and which has to do with what something says, and the word process, which is talking about how you reason something, are two different things. And when they make this title substantive due process, that's a contradiction. Okay, they want that little expression. They use that to justify making laws when they're not supposed to be making substantive laws. They're supposed to be interpreting the process. They're the process. Judges are the process. Legislators are the substance. And now they want to put them together and allow judges to basically make these decisions for us.
Yeah, and they do that intentionally. Again, join us. Text your questions or comments to 502-571-0970. If you believe in the mission and like to financially support Kentucky's Voice, text KY Voice to 53555. That's KY Voice to 53555. I want to pick up on that again, Martin, because I think that's crucial in many cases, but maybe never more than Roe and Obergefell. You articulated in the article the decision the majority essentially legislated from the bench was often the practice of this and other liberal courts. How did it actually play out in this case? Can you give us a little more insight on that based upon your understanding?
Well, and people forget that I debated the judge that decided this decision in Kentucky. Now, judges aren't supposed to debate because they're not supposed to be a part of that. They're not supposed to be political. And his very showing up there, they wanted to do it, proves my case.
Yes.
Yes. So, and one of the issues there, this needs to be emphasized is, yes, they said that that basically the argument that marriage has always been what it is an example of tradition, and tradition is not authoritative. And I'm sitting there thinking, wait a minute, isn't that what precedent is in the law? Yes. That's judicial tradition. It doesn't matter. Right. It's supposed to be primary for judges, but instead he was arguing that tradition was not important, and I it was hard to find what to say. Yeah. Other than you are completely contradicting yourself and you're completely going against the understandings in your own world, judicial precedent, which you're supposed to be bound by. But now, because you want to change the law, you're not.
We find that often with liberals, that they literally contradict themselves, right? Mm-hmm. Just to make their point or get what they want. Here's another issue. We've got a couple minutes. I'd like to get your thoughts on this. But literally, they know that tradition and precedent is important by the fact that they create law out of thin air to set the precedent so that they can go back to it later on and say, well, it's there, it's in the law, right? Speak to that.
They're going to argue precedent. They're arguing precedent now because now they changed the law, so now it's their precedent. Yeah. It's judicial sleight of hand, and they think that we don't notice it, and some of us do and are pointing it out. The other issue here, real quick, is they made the argument that you can't legislate morality. Well, we have laws on incest, and we have laws on prostitution and bestiality, and
minorities.
All law is moral. All law is basically saying you should or you shouldn't do this. Yeah, that's what law is. So they're undermining their own mind.
And once again, what they're really saying is you can't legislate morality, but what they want to get across is you can't legislate any morality that's different than our morality.
Right. You can't legislate your morality, but we're going to legislate ours.
Yeah, and they do it all the time. In this case, Roe, in this case, two of the most, we've had some back in the past. We know that Brown versus Board of Education is some of those others, same kind of things. But these two have been egregiously legislated from the bench, and that's what we're talking about here. Matt talked about it a little bit in the first segment and first half, and you're picking up on that. So when we come back, we're going to continue talking about the possibilities and what this may look like if Obergefell gets overturned. So stay tuned for us. Martin Cothran is going to join us again for our last segment here on Kentucky's Voice.
Kentucky's Voice is your home for real news, real people, and real answers. But we can't do it without you. Your financial support helps us bring truth to the forefront, hold leaders accountable, and give a voice to the people of the Commonwealth. Join the fight today. Give online at kyvoice.org or text KYVoice to 53555. Every gift makes a difference. Stand with us. Speak up. Stay strong. You are Kentucky's voice.
Radio online at kyvoice.org.
Welcome back to Kentucky's Voice. We could go on all day on this issue, but we need to wrap it up here in our last segment. To do so, we're going to continue with Mr. Martin Cothran, the Senior Policy Advisor for the Family Foundation, on the numerous reasons why Obergefell was wrongly decided and why it should be overturned. We've had one listener has joined us and asked the question, Martin, or texted us, I should say, and asked the question where they can find it. So let me give them that again. You can find the article if you go to the KentuckyFamily.org. That's the Family Foundation's website, Kentucky spelled all out, KentuckyFamily.org, and then search for the article. You can find it on Kentucky Today, and then it will be out in the Family Foundation's Citizen September edition, which will come out and hit the mailboxes here in the next week or two. So be looking for that. Again, join us. Text your questions or comments to 502-571-0970. If you believe in the mission and would like to financially support, text KY Voice to 53555. By the way, Martin's going to be joining us at the Family Forum in Kentucky at the Embassy Suites in Lexington on March 27th. September 27th. So we look forward to that, Martin. We get back to our topic of the day. You rightly compare, as many have, but you did a great job, Obergefell to Roe. Explain to our listeners or viewers, however they may be joining us, the similarities and perhaps most of all the political proclivities or predilections, as you state in the article, that should lead to this case being overturned. Yeah. And I think, as I've said before, Obergefell is the Roe versus Wade of marriage. And the reason I have said that is because they used exactly the same reasoning in doing it. And they were doing a very similar thing, which was taking an issue that had been, to that point, decided by voters and took it out of the democratic process altogether and imposed their opinions on what the law should be. And in that process also taking an issue that was very much opposed by the majority of people, and just using their minority opinion to impose it on everybody else. I mean, abortion was very much opposed at that time publicly. Yeah. Yes. I think there was some 75% of Kentuckians had passed a constitutional amendment banning same-sex marriage. It had more votes yes for it than any other ballot initiative had yes and no votes. Yeah. And so this was very decisive. Now, one of the things we need to remember is that some of those opinions have changed, because they've had a lot of years to propagandize people about this. And so that would be harder to do now, but it still shouldn't be in the hands of judges. Right, absolutely. And I mentioned this, and you gave some insights in the previous segment for our listeners. So we're going to come back to this a little bit deeper here as to legislating from the bench, amounting essentially to judicial tyranny, or Thomas Jefferson prophetically spoke against that as creating a despotic branch. Mm-hmm. Along those lines, your plea and your quote is for the court to be willing to revisit and reverse its own deeply flawed and anti-democratic rulings. Justice Thomas made the same thing when they overturned Roe, right? Elaborate a little bit more on this for our listeners or viewers. Right. Well, this is the other irony, is that only the court can overturn the court. Right. And so what you need is a different court. And what has happened in the last few years, because of
the success of Republican administrations and their ability to appoint new court members is that we have now put on the court a conservative majority. And when we say conservative majority, we mean that differently when we're talking about judicial matters than we are, larger political matters. A judicial conservative is not one that legislates conservative laws from the bench.
Right.
A conservative judge, what it means in that context is he's not legislating laws from the bench at all. Right. He is simply interpreting the law that's there. And if I can say this, because I think this needs to be stated very simply and straightforwardly, that a judge is a referee. If you were watching a game, college football starting this year, yes. And if I'm watching a game and I see that the referee, I find out that the referee likes the other team, and then all his calls are in favor of the other team, despite what actually the rules were in the game, I'm going to be very upset. Yeah. And this is exactly what's going on with the court. You have the referees rebelling against the crowd and making the game go the way they want it to go. Yeah. This is what's happening here.
Yeah, that's a great analogy, especially with college football and NFL starting up in this weekend and next. But you mentioned something earlier that I think ties in with this very well here, especially when you talk about conservative jurists. Those who stick with the law or the Constitution, right? Mm-hmm. So it's a simple question, right? Simple question. Why then does the historical perspective matter? We talked about that a little bit last segment. Why does that matter?
Well, it matters because judges are supposed to take two things into account: the law and precedent, okay? And by precedent, they simply mean their previous decisions. What have they said before? They go back in the law books and they look to see what they said before, and that has authority. That's judicial tradition. That's the tradition they're supposed to be following, right? And so, that's the role of the role of the judge is very narrow and limited, right? And he's supposed to be the guy who arbitrates between this party and this party fairly on the basis of the law and of the basis of his previous decisions.
Yeah. And again, we said this in this last segment, but it bears repeating as we have radio listeners that may have just gotten on. It's amazing how liberals, once again, don't want to succumb to constitutional precedent, but they will talk about precedent when they have legislated from the bench apart from the Constitution. That's a fair statement, isn't it?
Yeah. Precedent is not important when I violate it, but it's really important when I make a decision on the basis of when I did violate it before.
Exactly. Very, very convoluted, but very well said. And that's exactly what you get with them. And that goes back to Kennedy's majority opinion on this and so many others. I love how you ended the article. We want to kind of wrap up on this. So I'm just going to quote you and then let you explain a little further. It goes along with what we've been saying. Judges have their place, a place alongside, not in opposition to the people. And then I said this, and may I add, not in opposition to the Constitution or the law. Elaborate on that. Well,
Justice Antonin Scalia, the late Justice Scalia, he really articulated this well. He was a good writer in addition to being a good reasoner and a good judge. Yes. And he said, what we have in charge right now is the black-robed supremacy. All right. These are like high priests or something, and they think almost in those terms. And they think they are wiser than everybody else. And they're not. There's wisdom in the people. There's wisdom when you allow the biggest body of people to make the decisions about what the laws should be. You can't let a small minority of arrogant people make these decisions. That's tyranny, right? And it's not just judicial tyranny. It's tyranny when one branch of our government gets out of its lane and starts taking over the others.
Yeah. And that's literally what Thomas Jefferson was concerned about. I mentioned it in the previous question a couple of questions ago when he called it, if we do what you just described, we are unleashing a despotic branch Give us just a little insight as we close out on what he was saying and what you are basically repeating here and what that does to our country and our Constitution.
Yeah. Well, the founders were very wise, and when they sat down and they looked at all the governments that had ever been formed, and they wanted to do the wisest thing. And so they took the best of all the forms of government. And that's what we have in our Constitution, right? We have a democracy in there. We have an aristocracy in there, sort of, in a way, sort of with the court. We want wisdom there. And we have all these different forms of government that we put together in here to form a balance. And so our government is a balanced government. And when it gets out of balance, it becomes dangerous. And
checks and balances, right? Checks and balances.
Mm-hmm. Yeah, all through the system. All
right.
It was checks and balances because to protect ourselves from ourselves.
Yes. Yeah. And that's interesting because in our founding documents, it's literally stated from those men and the founders, this is a government of, by, and for the people. Mm-hmm. And it's why it's not just, but it is a government under the rule of law, which is a republic. So you have the democracy of the people, which you've pointed out, but not apart from the law.
Right. And they believe, they respected democracy, but they didn't exalt it. And they knew that people are sinful. And if you don't have the checks and balances to help correct for that, then you're going to be in trouble.
Yeah. And Martin, I hate to say that, but I see that same thinking has been infiltrated, heavily infiltrated, even many of our churches and our Christian parents and families. They have a false idea that people are good and born that way. Mm-hmm. If we were, we wouldn't need laws. Right.
Right. So, we have a democracy. So in one sense, the power is distributed widely, but then we protect it again by having three branches of government that correct each other. Right. Jefferson was really when he was forming school districts. Yep. There were so many checks. I remember reading one of the documents, so many checks and balances, and they're going, whoa, this is overkill. We need that. Yeah, and if we let it go, we're going to hurt ourselves. Because
we're flawed. Right. We need to have the checks and the laws. So I want to give another big thank you to you, Martin, for joining us, and to Matt Staver and the Liberty Counsel for the work they're doing, and in particular with this case, as well as encourage our audience to be in fervent prayer for the Supreme Court justices and these decisions. We must stay alert, active, and prayerful, and in faith, know that we'll see God's hand in these situations and across our Commonwealth and nation. A special thanks again to Martin Cothran for this excellent insights, and please keep up the great effort on behalf of all conservative Christian citizens. I'm Greg Williams. Make it a great day, and God bless in the love and lordship of Jesus Christ.